first case before us this morning is Nick Molnar versus City of Green et al. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, wish to reserve any time for rebuttal, I'm keeping the clock. I can let you know about the passage of time. You've read the brief, you're ready to see more.
May it please the court. My name is Frank Scaldone. I represent the City of Green, Law Director Calta, and Mayor Nuggebauer. I'd like to reserve 5 minutes of my time for rebuttal. When a court orders a public entity and its employees to produce public records, they cannot be stripped of their immunity under the Tort Liability Act when a third party sues them for complying with that order. As brief background, and I understand you've read the briefing and I appreciate that, but as brief background, a media organization had made a records request regarding the separation of employment by the plaintiff with the city. Ultimately, after the city did not produce the records, the media organization sued the city to compel them. The city vigorously defended the suit in an effort to avoid producing the records, but ultimately the Court of Claims determined that the records had to be produced. Now, plaintiff claims that he had a contract with the city to not produce the records. Here, the trial court denied without explanation the benefit of immunity, the city and the individual defendants. Our position is the trial court erred as a matter of law because first, the purported contract is not enforceable, it's void from its inception. And two, complying with a court order to produce public records cannot constitute an exception to immunity under Ohio's Political Subdivision Tort Liability Act. As far as the City of Green is concerned, Ohio's immunity statute provides broad immunity, presumptive immunity. So once it's raised, there's a presumption of immunity, unless 5 specific exceptions, one of the 5 exceptions applies. Here, the plaintiff doesn't argue that any of those exceptions apply. He didn't argue at the trial court level, and he didn't argue on appeal that any of those. He cannot, because the production of a public record is a governmental function. There are no exceptions.
Counsel, this was a 12b6.
Correct.
And so what is the most important is what's in the actual complaint. So there is an amended complaint that was filed, right? And in that amended complaint, the city, I can't remember right now, the City of Green was sued, or were they just sued? They were sued in their official capacity and their personal capacity, right?
The city was, yeah.
The city was named.
The individuals were sued both, not only in the official capacity, which is akin to the claim against the city, but also the personal
That's
capacity.
what I was saying.
Yeah.
So they were sued both in their official and personal capacity, and I know the name of the suit is the City of Green, but sometimes people put things on a complaint that doesn't mean it's any allegations that they're actually making. Anyway, so the point is, they were sued personally as well as in their official capacity. So there were individual allegations of bad faith, of different things that were raised in this complaint. How do you get rid of that on the 12b6?
Well, first, the mere allegations of willful, wanton, malicious bad faith are legal conclusions that are not entitled to the presumption of truth in a 12b6. There's a presumption of immunity. I think the way that, the most effective way to deal with that is, in addition to that, is all of the claims for this reckless, wanton, the factual allegations, if you will, derive back to this violating this purported contract. So I'd like to talk, and really that's plaintiff's argument. Plaintiff says, well, we had a contract, therefore, immunity does not apply at all. And I'm sorry if I'm kind of deviating from, if you'd like me to address the individuals, I can do that, but I think it's related to the contract issue.
Yeah, I just want you to address what's actually in the complaint.
Sure.
Because I know your point is, and that's what you've argued in your briefs, well, these are all legal conclusions. But, they presented some, just some excerpts from the complaint and then made some arguments as to the personal allegations they made that, that represented that the termination letter was rescinded,
Right.
That it would be destroyed, all those type of things. That is kind of beyond just a violation of the contract or what you were ordered to release as a public record.
Right. So the response is, exactly, so it does derive, it directs right back to the contract. And the fact that, I think it's pointing to the law that's cited in the brief, that a city cannot agree to violate public records law or to keep a public record from the public.
But they didn't
And
agree to do that, did they? You said the contract was void, and I said they didn't agree to do that, did they? Because they had the provision that said subject to the public records.
Right, but I'm saying that's not the only reason. When you read the contract, you're left saying, well, it doesn't even say that in the contract, but that kind of goes to the merits. I'm talking about the contract itself is void at its inception. So anything that's derived from it, if you're claiming that the mayor or that the law director acted willfully and wantonly by failing to adhere to this contract, what I'm saying is, and the Supreme Court supports me, is that that contract is void at its inception. It's as if it never existed.
You're saying basically a city cannot agree with a private individual to destroy a public record. That would be a violation of the Public Records Act, therefore it's a void contract.
Correct.
Gotcha.
And the Supreme Court in State XRL Findlay Publishing Company, 80 Ohio State 3rd, 134 at 137, expressly states that, quote, public entity cannot enter into enforceable promises of confidentiality regarding public records. And there's no dispute here that we're talking about public records. The Supreme Court has held as much. The plaintiff admits that they're public records. And the 9th District has expressly held that, and this is in Teodecki versus Litchfield, 2015, Ohio, 2309, that has held that a contractual promise of confidentiality with respect to an otherwise public record would violate public 149.43 if enforced. And such provision is an agreement is void ab initio, and that's where the support for that it's as if it never existed. Void ab initio as if the contract never existed, and there's extensive case law to support that. So that really addresses not only the city's liability, but the individual's liability, whether they're making allegations, legal conclusions of recklessness, maliciousness, bad faith. It all derives from that. So here, it's difficult to conceive how the individuals complying with an order from a court of competent jurisdiction could be acting recklessly or maliciously, or otherwise failing to comply with a contract that could never exist at law would constitute malicious conduct. It simply doesn't. You know, as you look through the complaint, you can see that there's really no explanation or any meaningful allegations of how the law director or the mayor acted with this high level of culpability outside of what we had just discussed. With the mayor, there's there's just simply nothing there that would explain that high level of culpability. And really, the same is true with Law Director Calta. So simply complying with a court order to provide public records cannot rise to that high level of culpability that would strip these public officials or the city of immunity. Unless there are any questions right now, I'll reserve the remainder of my time for rebuttal.
You'll have 5 minutes for rebuttal. There are about 6.5 minutes remaining. Seeing none.
Okay, thank you very much.
Good afternoon, Your Honors. I'm Brian Carr for the appellee, Nick Molnar. Judge Carter, Judge Hensel, it's a pleasure to see you again. Judge Teodosio, it's nice to meet you. The appellant, I believe, is misreading and misinterpreting two very basic civil rules, Civil Rule 8A and Civil Rule 12B6. The appellee is not obligated to prove his case at the pleading stage. That's obvious, that's clear, but apparently it's lost on the appellant. I think it's very important because there are a couple of questions directed to this Court of Claims debacle. The first problem that I have is there is clear case law, and I articulated the clear case law to the trial court, as well as in my appellate brief, that a municipality certainly can make an agreement to remove items from a personnel file. That's what we're talking about. We're not talking about an agreement to destroy public documents. That's just nowhere contained anywhere in any allegation from my side or the other side of the table here. There are two cases directly on point that say that a municipality can agree to do that. It's clear. There has been no case law cited by the appellant to contradict the established case law that I put in my brief. If the appellant's theory was correct, then a municipality or a municipal officer, a mayor, a law director, a council person, can draft any kind of document, defamatory or otherwise, put it in someone's personnel file and say, okay, there it is, you can never have it removed. That just doesn't pass muster. And another point that contradicts the entire position of the appellant is that in the Court of Claims filings, and this was raised to the trial court in my appellate brief, the law director acknowledges in pleadings and motions that she signed and filed that the city destroyed copies of this letter anyway. Which begs, I'm sorry?
Why is that relevant?
Well, because if this case was about we can't destroy public records and we should be able to rely on the Court of Claims decision, well, the city destroyed copies of this letter anyway. Which begs the question, how did Channel 19 get their hands on it? But prior to Channel 19 filing the Court of Claims suit, my client, through myself, was making a demand upon the appellant, the appellants I should say, destroy that defamatory document as you contracted to do. That fell on deaf ears for about 3 or 4 months. The Court of Claims matter was filed by WOIO, I want to say in October or November. We were never notified. We had a direct interest in that litigation. We were never notified. So it's not res judicata because we were parties to that action.
So your claim is for more than just the release of the document?
I'm sorry?
Is your claim for something other than the release of the document to the television station?
Well,
Are you saying?
certainly and I don't mean to interrupt you. Yeah, in the amended complaint, we've got claims for breach of contract, defamation.
But doesn't it all relate back to the release of the document, not necessarily whether it was destroyed or not, the fact that they released the document?
Both.
Both.
Yes, because prior to filing the litigation, we just wanted it destroyed. We didn't know Channel 19 was looking for it up until maybe, I want to say the litigation was already pending in the Court of Claims. We were never notified of that litigation. So we didn't have any opportunity to argue in the Court of Claims or raise our position in the Court of Claims. There's never been any acknowledgement from me or my client that this was a public document.
So your argument would be they breached the agreement because they did not destroy the document?
Clearly, absolutely.
So, can you address his argument that it's void ab initio, the agreement?
Well, sure, and as I said when I began my argument, that's just not the law. There's case law that I've cited in my brief, not only to this court, but also to the trial court, where it says municipalities can certainly make agreements to remove matters such as this, documents such as this, from a personnel file of a city employee.
So are you saying your breach of contract claim does not fall under the immunity statute?
Absolutely not. And what I was going to argue, my mission statement, so to speak, at the beginning of my argument was going to be, this is not an immunity case. They would love for it to be an immunity case. It's just not. This is a breach of contract, defamation case that they wanted to try to run under the umbrella of 2744 when it's just not there. They should have destroyed this document.
I thought you started your argument by saying nobody is asking for any records to be destroyed.
No, certainly, we wanted that letter, that defamatory letter, all copies
I
destroyed.
thought you just wanted it removed from the personnel file.
It was to be, they were all, we wanted the agreement to be complied with, which I believe was destruction of all those copies of a letter. Although I
So
will.
why are we talking about that removal? I'm so sorry, but I'm confused by both your arguments, to be honest with
Sure.
you. It's not just, I'm not just picking on you, I was confused with some of the stuff the other side was saying too. So I thought it was destruction, but then I thought you were saying that the agreement was for removal of the
the agreement that was reached, and I wasn't representing the appellee at that time, the agreement that was reached between the appellee and the city was that this defamatory letter that was in his personnel file would be removed and destroyed.
Okay, so the terminate, they're talking about the termination letter.
Yes,
Okay, and that was rescinded as part of the agreement.
correct. Well,
Okay, so it was basically, and I'm gonna use, I hate the term void, but for a number of reasons not to deal with this case.
Mhm.
But, so that was voided out basically, according to the agreement.
Yeah, what the termination letter has some defamatory language in it, and the appellee said, you know, I want the opportunity to resign, and I want that letter on my personnel file, it makes me look like a racist. And the city eventually agreed and said, we will take that letter out of your file, we will destroy it, and you'll be allowed to resign and not fired. Now, the question, and again, this is another reason why, you know, 12b-6 just simply doesn't apply, because we have to get into the facts of this case. How many copies of this letter were floating around the city of Greene? There should have only been one copy in the personnel file, which the appellant in her argument to the Court of Claims said, we destroyed the copy of the letter, but apparently there's another one floating around. So our argument is that defamatory termination letter, you know, should have been taken out of the file, personnel file, and all copies shredded, destroyed, what have you. That's our argument, and that's why our position is immunity is a non-starter here, it's a non-issue, because it doesn't, we're talking about a breach of contract in a defamation case. We're not talking about immunity. The Court of Claims proceeding is just not
So
relevant.
what would your damages be?
I'm sorry?
How are you damaged by the fact that if it was just taken out of the file and nobody saw it?
I'm sorry?
How would you be damaged? I mean, what are your damages then?
Well, we don't.
You're saying that it should have been taken out of the file.
Well, we don't have any discovery, as you know, Your Honor, because right now we're dealing with the dismissal of the case. You know, we've got a defamation count, and when you have allegations or allege that someone is a racist, that could be defamation per se, per quad, what have you. We're just not there yet, because the trial court, I think in his wisdom, denied the 12b-6 motion.
Okay. Thank you.
Yeah, I want to thank you for your time this afternoon.
Opposing counsel argues that this case is not about immunity, but it's about a contract. And the reality is that the law is very clear in Supreme Court law that a public entity can't destroy or withhold public records through a contract with an individual. It's the law of, it's, the holding is that such an agreement is void ab initio,
Well,
which
but
means,
I'm sorry.
No,
But that could be a defense to a breach of contract. That doesn't necessarily mean you're immune, because you're not gonna be immune for breach of contract. Otherwise, you know,
no, there's
nobody in the public could rely on any of the actions of government, you know, to end those contracts.
no question of, if it's a contract, then the immunity would not apply to that, but because of the nature, because it's not simply void, the contract's not simply void, it's void from its inception. It's as if it never existed, and that's our argument. So
But-
this is not a,
But that seems to me maybe that's a defense again, that you're not guilty, you're not responsible, I'm sorry, I have too many criminal cases floating around my mind. You're not, going to be liable, maybe, for a breach of contract because there's no contract to breach. But isn't that a little different than you're immune?
yeah, I would disagree along. I think if you're dealing with an issue where the contract would be void, well then you're absolutely correct, it would be a defense to the contract. But when you're talking about a contract that is void ab initio, then it's as if the contract never existed at all. And I think that you take a different tack that way. And that is the basis of our argument. It's a firm basis that's supported by Supreme Court law, that this is not. I mean, this really is not about a contracted action at all. With regard to the defamation claim, I invite the court to look at the complaint. There's no allegation of defamation other than that the city defamed me. That's all there is there. And under any pleading standards, it simply does not establish a claim against an individual in their personal capacity. When you combine that with the immunity that is presumed, it certainly does not strip the individuals of liability for something like Some of the claims that were made, I mean, those are really the main points that I think require or support us winning the case. And I guess at this point, unless that there are any additional questions, I'll rest at this point and ask the court to reverse the lower court for all of the defendants on the basis of immunity.
Was the April 5th letter attached to the complaint as an exhibit?
The April 5th, that was the original, no, there's absolutely no, which is interesting, right, if that's the defamation that you're trying to premise your claim on, but no, it was not. The one that wasn't attached was the one that with the purported
The 26th.
agreement, the 26th, that deals with, that carves out the exception for the public records request and discusses that agreement. Unless there are any other questions, the rest at this point. Thank you, I appreciate your time.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision. We have to